My name is Mark Cohen. I'm Senior Counsel at the U.S. Patent and Trademark Office. I was actually formerly the IP attaché in the U.S. Embassy in Beijing from 2004 to 2008. My current role in Washington, D.C. is I am responsible for the China team at the U.S. Patent and Trademark Office, which consists of about 21 people in 4 cities. Washington, Beijing, Shanghai, Guangzhou, and our Shanghai office is responsible for Taiwan. So in that capacity, I'm engaged in everything involving IP in China, and as well as mainland China, as well as Taiwan, Hong Kong, Macau, and Mongolia. That's the geographical region. And that includes not only patents and trademarks, obviously we're the Patent and Trademark Office, copyrights, trade secrets, plant variety protection, geographical indications, what have you. Why does the Patent Office have the Senior Counsel for China? Actually, PTO and International Affairs, where I am, are organized. We have someone senior for patents, trademarks, copyrights, enforcement. There's only one country that has someone senior at this level, that's China. And that's because of the importance of China, perhaps the uniqueness of China and the issues in the region. Part of the reason I'm here is to better understand the environment for commercialization of intellectual property. I've certainly taken the approach, and as have many of my colleagues, that getting substantive adherence to treaties, to multilateral, plurilateral commitments is useful, but and enforcing those rights is useful, but also another benchmark of how good a system is and how we interact with it is whether companies are able to monetize their rights. So looking at the environment, the commercial environment, understanding it better, and how it interacts with the substantive law and the enforcement is also part of the mandate. China, we're going to switch for a moment to mainland China. China has some unique challenges, and I've testified this in the Judiciary Committee and some other committees on the Hill over the years. China is a big, China's by their own statements have said that they're a very big country for IP, not just a big country, really, but they're not a particularly strong country for intellectual property. What do I mean by big? Well, in some respects, it's huge because the Chinese Patent Office is bigger than the next 7 largest patent offices combined in terms of patent filings. The Trademark Office is also several times the size of the U.S. The U.S. historically was #1 in most of those areas. And litigation also is about, in terms of number of civil cases filed, probably an order of magnitude of 10 to 15 times the United States. So this is a big environment. Being big and having IP reflected in 5-year plans and industrial goals doesn't necessarily mean that IP has been transformative to the Chinese economy or that it's created and helped as much as it can in creating an innovation-driven economy. And I think that's certainly to a degree because of the contradiction between having an intellectual property system which has evolved and flourished in market-oriented economies. When you translate it into an economy that's transitional, or some would say not even truly market-oriented, you can't plan for innovation. If you start doing that, you start running risks. You have to incentivize failure. If you're going to innovate, for example, you can't punish people who fail. You have to recognize failure as vital fertilizer for other achievements. You can't really plan how many patents per capita and the like. It's problematic. Furthermore, the more you plan and the more you think about national patrimony, if you will, in intellectual property is a state asset, as a competitive advantage, it starts disadvantaging naturally foreigners. You start having all these other tools that come into play that depress the value of intellectual property. Antitrust would be one of them. It's not the only one. Maybe there's different practices in examining patents. Every country, to a degree, favors things that have itself. That by itself is not wrong, but if it gets too skewed, it could really prejudice foreigners' rights or ability to protect themselves. So China presents some unique challenges. For me, speaking personally at least, the easiest way that mainland China could migrate to an efficient and effective and innovation-promoting IP system is by greater reliance on effective civil remedies, and really by stripping a little bit some of the planned elements of its economy from intellectual property. Perfect example is trade secrets. You can have a state plan on how many patents per 10,000 people as China does. You can have a state plan on how many trademarks. You can't have a state plan on how many trade secrets. In a planned environment, trade secrets will naturally suffer because there's no way to quantify them. And then if you rely too much on state enforcement, whether it's criminal enforcement, administrative enforcement, antitrust enforcement, you end up depressing the value of the civil system. People don't resort to it. So, a measure, certainly not the only measure of how healthy an IP system is the availability of robust and efficient civil remedies. No country is perfect. The U.S. certainly has its own inefficiencies, so I'm not saying that. But damages are low in China. A lot of enforcement is in the hand of administrative agencies. Antitrust enforcement, in my own opinion, sometimes been overly aggressive. If we had damages that fully compensated the rights holder, then you would find naturally more innovation and creation. Now, one of the big disparities that I raised in my hearings on the Hill, which has been repeated many times, is that the Qualcomm case I raised as an example, which was $875 million, if I recall correctly, close to $1 billion in damages and a fine for antitrust violation by the National Development Reform Commission. It was in an order of magnitude that was, depending on which database you use, between 10 and 30,000 times average patent damages. 10 and 30,000 times. In fact, when I testified, the folks reviewing my testimony said, why don't you just say as much as 1,000 times, because no one will believe you. But when you have average patent damages of about $16,000, you have close to $1 billion in an antitrust fine. That's a huge difference. Now, most of the time, if you speak to an academic, they say, we don't really compare average patent damages to antitrust damages. But if you can't realize a value out of your patents, then how can you say you're abusing them? And it seems at a certain point there has to be a link between your ability to enforce your IP rights and the abuse of those IP rights. To be cute, I like to say you can't have abuse unless you have use. And I think China has been a country where use has been suppressed or has not been able to truly flourish. I think there's tremendous potential in China for innovation, but the civil system has been weakened too much. It's coming back, specialized IP courts. The damages are increasing. They're trying to use different methods for calculating damages. They're introducing modest levels of discovery. Judges have become more expert. People are aware that there are some real problems. But that's really, to me, the best way of creating an IP system that's market-oriented, that gets inventors and creative people in a position where they're incentivized to create more, which is the heart of an IP system. Okay, so let's talk a little bit about what we know about monetization. First of all, what we do know is all the data. I think that thus far, countries and country data or other data tends to be pretty flawed. So we take the data for what it is, and I think it provides useful comparisons. One country collects data like the United States about Japan, mainland China, Taiwan. Well, you could say this is how the countries compare to each other based on the same analytical approach. But is it comprehensive? Well, one of the examples at a conference today I gave is what about court judgments? The U.S. court judgments are not considered licensing transactions, even if they're in settlement of a patent infringement dispute. So let's put that off the table. If you're licensing through Ireland, that's a transaction with Ireland, not with the U.S., even though it might be Microsoft or Pfizer's or someone else's patents that are held in Ireland for tax purposes. So that's another distortion. Then people can license out to a particular country to manufacture, and rather than take a running royalty, they take it back in the value of the goods as declared as they enter the U.S. ports. That's what we call a customs assist. That may not be reflected in the customs data. So one thing it's just a note that really when we talk about this data, it's not as comprehensive as we would hope. U.S. data talks about industrial processes. It doesn't say patents. So we're assuming that industrial processes as a service is patents, but there may be stuff that's non-patents in there. Okay. And China and other countries have other problems with the way their data is collected. If you look at monetization, from what we see, probably China doesn't do as well as you might think. They're trying to ramp up their ability to monetize, and they've certainly taken some steps which are helpful, like they want to participate more in standard setting activities. It's one way, if you have standards essential patents, to be able to cross-license with other companies, reduce the amount of royalties you pay, and ultimately to collect revenue in your own right. Huawei, ZTE, and others have been very aggressive in filing more patents internationally, and probably getting into much better positions vis-a-vis particular 5G standards, from what I know. So that is something in progress and probably headed in the right direction. There have been other things that have probably been less successful. For example, China has a program on hypothecation of patents, collateralization of patents. It seems to be state-supported, and it has created some high patent values, but that's usually because it's bundled with the overall value of the asset being mortgaged to collect financing. So that data, I'm a little bit suspicious of whether it really represents the values that are intended. Particularly if you have low patent damages and you're seeing these high values for patent mortgages. It doesn't make sense. You can't get more from the patent than you could if you had to go to court on an arm's length transaction. China buys about $5 billion, pardon me, of U.S. technology under that industrial processes classification. Is comparable to Taiwan. So as a buyer of U.S. technology, mainland China and Taiwan are pretty comparable. As a manufacturer, China is the world's largest high-tech manufacturer. So China is responsible for about 5% of U.S. Technology export revenues. But if their payments were equivalent to their role in high-tech production, then we would probably be at another $15 to $25 billion per year. There are other comparisons to make, but it seems not only based on that, but companies that report, it's very hard to license for the domestic market in China. The numbers of litigations that occur overseas as compared to domestically in China because of the difficulty of extracting rents or royalties from China. That China is probably a severely under-licensed market. And also the fact that foreign companies rarely litigate in China. 1.3% of the IP litigation in China involves a foreign element. So we're not actively enforcing our rights, probably because we find it not cost productive. So I wouldn't hold up China as a model, certainly for foreign commercialization of foreign technology. They are creating markets a little bit of a top-down way, and they're trying to find ways to support this massive amount of IP activity going on, including subsidies for applications and the like. You do see, historically, we've seen a trail off in maintenance rates, so the subsidy goes to filing the patent, but it doesn't go to the renewal. So patents tend to trail off because you're getting money for the application, but not for the subsequent renewal. I think Taiwan is in kind of a unique position because of, particularly based on today's program, one of the core sectors to its economy is fabless semiconductor design, and that is highly licensing dependent. And if you look at it just in terms of Taiwan's patent portfolio in the U.S., about 2/3 of the applications are related to either semiconductor manufacturing technology or semiconductors themselves. So this is a very semiconductor-dependent IP economy. Because of that, the data also manifests itself that most of the licensing transactions occur between unrelated parties. So we're licensing into Taiwan to an unrelated party that then needs our technology to take another step in manufacturing and designing a product. That's unlike China, where most of the licensing is going to a related party. So in Taiwan, it's 90+% as an unrelated party transaction in Taiwan. In fact, as an unrelated party licensing market, which may sound like a rather obscure heading, Taiwan is the largest market in the world, which is also pretty remarkable. To me, that is a representative of confidence in the market. If you're not confident in the market, and there could be other factors like the size of the market that affect this, but if you're not confident that in even a small market, you're unlikely to license to an unrelated party. If you think your technology is going to get stolen, you think you're not going to get paid, the courts aren't going to work in your favor, then you're probably not going to take your IP and license it in most circumstances. I think if you compare all three of these markets, the U.S. has generally had, particularly in recent years, a rather light hand on antitrust, which I think also helps in giving flexibility to companies and how they monetize their assets. We don't have a separate set of rules regarding foreign-related technology transfer. We just apply the same law throughout. China has a separate set of rules, like the Administration of Technology Import and Export Regulations. So that also creates a more difficult regulatory environment. And I think most people believe that the U.S. legal system functions in a fairly impartial way. And you can get arbitral awards enforced, but also that the legal system is well enough developed, predictable enough, and doesn't disadvantage a non-U.S. party. If you're looking at choice of law as a bellwether, which to a degree it is of confidence in the legal system of choice of venue, there was a survey done by an organization out in Hong Kong some years ago, which showed that in China-related technology transfer contracts, a very high percentage of parties to those contracts would choose foreign law or a foreign venue. Taiwan actually, and we spoke about this today in this conference, Taiwan does maybe have some latent possibilities to do more in terms of being an inviting market for U.S. technology. Maybe, to just name a few things, maybe the experience of a largely semiconductor-oriented technology transfer environment could be brought to bear in other technological areas. Maybe it could work out well in biotech, in R&D, and maybe you could have more activity in developing new pharmaceutical or biological compounds and the like. We also heard today that there's possibilities of enforcing judgments from Taiwan courts in China. Maybe Taiwan could do better in its court system and become more of a center for dispute resolution of intellectual property. And maybe people would have similar confidence in the court system like they have in their ability to license in. So there's actually probably a good deal of potential worth exploring and looking at how Taiwan could be a better platform for cross-straits technology transfer or even regional technology transfer. But having adequate civil remedies and compensation for rights holders is critical. Low damages will deter innovation and they become a benchmark. It also, you have to realize that the patent system is often the last recourse, the legal system, for the inability to license on a negotiated basis. I understand, I used to go to Barcelona a lot, I understand there's a curse in Catalan, which is may you be involved in a lawsuit in which you know you should win. Because having to fight something out in a court of law for something that you feel you're entitled to can be extremely painful. And if you don't set up a system where you gain nothing by litigation. For example, if you say, in a standard setting context, the royalty is 0.1% if I negotiate with you. And if the courts award that same level of damages or less, then there's no incentive for anybody to enter into friendly or non-litigious or non-court-based negotiations. So you have to have courts that recognize the nature of the licensing process and their role. There should be a cost associated with delay. There should be a cost associated with enforcing, just like there is a risk for the licensor. And the courts have to, be able to handle that in a sophisticated way, not to be punitive about it, but to recognize that most of the enforcement, most of the licensing that goes on in this world goes on a voluntary basis, not because people have to go to court. That's the last resort, and one that is used, the costs associated with it should be fair and should help to promote innovation. Again, the example of China, where if you have very low patent damages, what's the incentive to settle? How can you really have use? Can you really even have an antitrust system when you're saying there's abuse of IP when you've had so many problems trying to use the IP rights in their own way? Of course, if you have very high expenses with litigation, that could be another factor making the system harder to manage. How technology is evaluated, the expertise of the judges. Some of those issues are internationally controversial, and we have a specialized appellate IP court in the United States. I've heard some judges say that it would make better sense to have specialized trial courts, not appellate courts. All these things can also affect the strategy. We also see today people choosing venues for IP litigation, particularly if it's multinational litigation, and increasingly, Germany seems to be a preferred venue. Some people are going to China because China is low cost, and you get injunctions. In the U.S., injunctions have been somewhat more sparing in recent years, so that also changes the equation. A lot of civil law systems, and I suspect Taiwan as well, generally grant injunctions fairly readily. What they don't do is award high damages, and that can be a problem.